The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi everyone, welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz, along with my guest co-host this evening, Paul Esslinger. Paul's filling in because our usual host, co-host, Tony Palmieri, has a previous commitment this evening and couldn't be here. So I want to thank Paul for joining us this evening. And this is the second show tonight that we've taped, and
I'm still here.
Still hanging in, so that's a good thing. On this show, we're going to be talking with two of Winnebago County Circuit Court judges, Judge Scott Woldt and Judge Barb Key. They have put together and worked with some other folks in the county to actually get facilitated and instituted, as of this year, a drug court in the county. And we're going to find out, first of all, what a drug court is, what it does, and why we needed one here in the county, and the benefits that it serves. So thanks to both of you very much for being here tonight.
My pleasure.
I guess the first place to start is, what is a drug court? I mean, we all know what court is, but what's a drug court?
I'll let you start.
Okay.
All right. See how he passes that off?
That's
I learned quick.
A drug court is something different than anything that you've probably seen in the courts up to now. Certainly in this county or around the state, a few state counties in the state have it, but not many. And it's pretty different than anything else we've done before. It's something in which it's all centered around the offender and the judge and a team of professionals from the DA, the defense attorney, and a treatment provider, probation agent, and the drug court coordinator, all working toward the goal of trying to help this offender become drug-free. The whole concept is based on the whole theory of get treatment for the individual, hopefully save them from going to prison. That's what the whole purpose here is, and to make our streets safer. But it's all centered around, in the court, giving the offender the chance to get treatment. And if they don't have treatment, we're going to have they'll be coming to court every week and being tested every week to see whether or not they're using or not, and giving them and making sure that they get the treatment that they need, and giving them sanctions if they violate, and giving them some rewards if they don't. And we've found that throughout the nation that these programs have been working quite effectively, and so we're ready to go.
Well, when I think of court, I think it's what anybody thinks of. It's a building across the street, and you're there because you're involved in a civil case, or you're involved in a family case, or you're involved in, God forbid, a criminal case. A drug court, this is not a separate building. It's a program, I guess, but it's called a court. Is that?
Yeah, in fact, Barb and I both went through a week's worth of training through the National Drug Court Institute. And one of the things we've learned about talking with our drug court team, how we're going to set up the courtroom. Because we don't set it up like your normal courtroom. It isn't supposed to be adversarial. So you don't have DA on one side, defense attorney on the other side, defendant standing by them. We have the defendant, when they come in, come right up in front of the bench. It's more of a conversation with them. The DA, prosecutor, the rest of the drug team, they're going to be in the jury box. So they're all sitting together off to the side. And we meet about an hour before each time we have a drug court session. We staff these people, talk about what we're going to do, and it's a team decision, what we're going to do with these people. We saw some judges that would have on the front of their bench a rope. And when you go through the AA process, when you get from one step to another level, you get different bracelets. One judge was kind of neat. She would collect all the bracelets from all the participants in the program, and she would put them on a rope in front of her bench. So she would see all the people that have gone through there. Barb and I were talking the other day, it's kind of like social work from the bench. That's what we're doing. We're talking with these people. We're getting to know them. We write down their names, their families' names, kids if they have them, where they're working, if something happened in their family. It's more of a conversation with these people, getting to know them, making them feel at ease. And we do that because we want to have a closer connection with these people because we're seeing them all the time. We're seeing them at the beginning once a week when they come in. And we want to build this relationship with them, so hopefully we can keep them from coming back.
Okay. Well, let's start at the beginning. How does this work? Someone is busted for drug possession or drug dealing. How does one make a determination if they're eligible for the drug court? And walk us through the process. They're busted. What happens?
Well, at the beginning, when someone gets busted, and I'll let Barb talk about how someone's qualified, but the way they get into the program is when either the district attorney, the defense attorney, a family member for the defendant, a treatment provider, or a judge refers that person to the drug court, think they're a good candidate, they would refer them to the drug court coordinator, who was Carol Cook, county board authorized social services to hire her. We have her through social services because we want this to look more rehabilitative, because that's what it is. They'll meet with Carol. Carol, we were lucky to get her. She has a master's degree in social work. She's a certified AODA counselor. I think she was on your show before, and she was working at the DAC, DAC, the Drug and Alcohol Correction Center here in Winnebago County, and she helped develop the Earn Release program, which is a drug treatment out there. Right a week before they're going to start, we kind of stole our way from them, which was our coup. We got lucky. So they go through her, and she assesses whether or not she qualifies, and I'll let Barb talk about all the qualifications. Then, once they qualify, they come back to court. The judge will, if all parties agree, the judge will then, if Barb or I don't have the case, because we're the only two drug courts, if we don't have the case, there'll be a judicial transfer from that judge to us.
Okay.
At that point, we do the sentencing. We'll place the person on probation. Condition of probation will be that they successfully complete the drug court program. And then they refer them over to the drug court program, and they start seeing us every Friday at 2 o'clock.
Okay. We'll get into the specifics of the program, but now, so it sounds like making a referral, if you will, into the court, the drug court, is sort of a collaborative effort. Family members, defense attorney, district attorney, if everybody else sort of agrees that this person might be a good candidate for the drug court, but the DA says, this is an offender who I just don't think would be suited for this. Can the DA, by himself or herself, in a county where there's a female DA, stop that from happening?
So far, we've taken the position that that's how we're going to handle them, at least at the beginning. I don't know if that'll change at any point or not, but practically speaking, again, this is a team approach that we're involved in here. And I think we've agreed from the beginning here that we have to all agree as a group to start with that these people are appropriate for the program. So if the defendant doesn't want to be in the program, he doesn't have to be in it. If the prosecutor doesn't think he's appropriate for it, we're not going to at this point. There may be some legal issues as to the judge may have the authority to do it, but practically speaking, we don't think that it's setting the whole thing up for failure for that individual if the prosecutor or one of the members of the team isn't in agreement on it.
Okay.
So.
All right.
Well, I just want to go touch back on the referral part. I want to understand this. If I'm a parent, say I'm a parent and I have a child that's 16, 17, 18 years old, and I believe my child has a drug problem, can I go to Judge Key or Judge Woldt and say, my child hasn't been convicted of anything or hasn't been charged with anything, I think there's a problem. Do you go to a court, or do they have to be convicted of something? Do they have to be charged with something? Can you talk about that?
They have to be convicted. This program is set up, first of all, it's going to have to be adult offenders, not juveniles. That's not to say someday it may not expand to that, but at this point it's for adult offenders.
Okay.
They have to be residents of the county. It has to be a nonviolent felony, but the offense for which they're being sentenced and placed before the court has to be one that's somehow drug related. Whether it doesn't have to be someone that's, say, a drug dealing or some other felony possession charge, but it has to be somehow driven by drugs. So say the burglar, the person who breaks into the house and they're high on drugs or alcohol or both, those are the ones we're looking for. And they have to also fit the criteria for drug alcohol dependence, and there's a specific criteria that they'd go through that Carol will end up doing the assessment of. And so it won't just be for someone who has some insignificant drug issue, although you can argue that you hit the whole spectrum here, but it has to be someone who fits that criteria for drug dependence under, what is it, DSM-3, I think?
4.
Or 4. So it's going to be the ones we're looking at right now are those that are one step away from going to prison.
So basically then an officer arrests John Doe, who's an adult. Citation gets written up, that gets turned into the police department. Does that go then to Judge Key and Judge Woldt? You guys review it, or does the police officer say, I think this person should go to you guys? How does that work then?
They can. The officer can make referrals too. Law enforcement can. The way we foresee this happening is if any of those people, because they would be charged at this point, we want to make this process streamlined. So when they're charged, we want those people to make those recommendations the first day. So it goes to the DA's office, they make their recommendations. If there's a defense attorney involved, they cut their deal that, yeah, we're going to put him in there. Right away, they refer him to Carol. I drafted a form for the district attorney's office, and we gave them to all the defense attorneys for that referral form. So they sign that form, all the people sign it, the defendant too, because the defendant has to voluntarily agree to be in this program. They sign that form, they send it over to Carol, Carol assesses them. Carol has a form she sends back, going through all the things Barb just mentioned, whether they qualify. She sends a letter back to the court, she has that form, whether or not they qualify. If they qualify, she sends along a form that's a judicial transfer form. That goes back to the judge. So the judge knows the parties agree, they qualify, they have the form, they do the judicial transfer, the next day it's our case.
If I'm the defendant and I'm charged with a drug offense, I have to agree to it. Why do I want to agree to this? Is there different penalties? Is there different forfeitures? If I want to go to regular court or if I want to go to the drug court, why do I want to do this?
Good question.
Exactly. And that's the question that is being asked by the defense attorneys right now too. And that's why we're saying these are the individuals that we say are one step away from going to prison, basically, or from long term of county jail, where there is an incentive for them to go through this program. Because it's going to be a very difficult program to go through. And we can go into the more specifics later as to how many times a week they're going to be tested, how they have to come to court, how they're going to have all the different treatment programs they're going to have to be through. This is going to be a tough program, and there has to be incentives for them to be in it. But it's going to pretty much start realistically with those who, if you don't do this, your alternative is much worse.
So if you go to regular court, you're rolling the dice. And if I'm the defendant and I know I got busted and there's a lot of evidence against me, I'm basically then saying, well, maybe I want to go to Judge Key or Judge Woldt because, yeah, I'm going to get tested, I'm going to go through some more hoops, but there may be some mitigating circumstances why I want to do that.
Yeah, a lot of these people that go through this program are doing it because they want a lifestyle change.
Yeah.
They want to change their lives. They want to stay in the community. They have family. They have kids. They want to continue to support those kids. And to go through this program and successfully complete it, they're going to have a lifestyle change, a huge change. All the statistics show that someone with one of these types of drug charges that does not go through a drug court program, their recidivism rate is 48%. So if you look at that, 1 out of every 2 comes back into the system.
Right.
We do it again.
Right.
And jail is $51 a day. Prison is $28,500 a year. It's expensive. Now, all the national statistics show that if you successfully complete a drug court program, the recidivism rate is as low as 4%, as high as 29%.
Because they're under the microscope quite a bit.
That's huge. If you start talking 100 people, and let's say we can save 96 of them from prison for a year, 96 times $28,500, you can start doing the math.
So if there's a violent crime involved with this, they're out there. Okay.
What, I hate it when I've got a question right at the tip of my tongue and all of a sudden it's just
lost
gone,
your train of
just
thought.
like that.
That happens on the bench, too.
No, it did come back to me. So this is not the kind of a program then where someone gets busted for, I don't know, $100 worth of pot. And, they may be facing a fine and some community service or whatever the punishment is nowadays for something like that. This is not a program designed for that kind of problem or that kind of defendant.
Yeah, but I think Barb said it best, or she said, this is the person that's on the doorstep of prison.
Right.
They come in front of me, they don't want to do this. I'm thinking I'm sending them to prison instead.
Are they avoiding any incarceration by doing this, or is there still some incarceration along with this as part of the program?
That'll be on a case-by-case basis.
Okay.
And some of them, there may be some jail time, and there may be some incentive for some, but that will be handled on a case-by-case basis. But we do, and that is part of this, we foresee that there will be less county jail time for these individuals too, that others who may have otherwise been spending time in jail pre-charging or pre-sentencing time may be able to get out sooner that way and actually save us on the front end with regard to the county jail time as well, the costs of that.
Sure.
Judge Woldt, you were explaining that this is basically for people that are on the doorstep of jail time. But could you see, for instance, Cheryl was talking about that person that got arrested for $100 worth of pot. What if that person had just lost their job, started smoking marijuana, doing cocaine, whatever else? They just got busted for a small infraction, but they have enough sense to say to themselves, I can see myself spinning out of control if I don't have some help here. Is that person a candidate for your court?
The person that has his wits about him enough to know that they have that problem and need that help probably doesn't need the drug court.
But what if they do need their hand held?
It could be. They could be a candidate. I wouldn't foreclose them from being in it. If there's someone that has a horrendous problem, you hit it on the head when you said lost their job, because part of this drug court is not only the alcohol training, but it's cognitive training. It's going through treatment for that. It's vocational training. It's finding a job. It's doing community service, doing all things that are positive for the community. So if someone they're a first-time offender, and all of a sudden they just like you said, spin out of control, and they need the program, I don't see a reason why they wouldn't be in it.
Okay.
And again, there are other programs that may be out there that may fit that type of offender who isn't necessarily at the dependency stage. And I think that's probably where there'll be different types of offenders involved. And some of those may be more appropriate for, say, volunteers in probation or some other things that are already available. So what we're looking at here are the ones who really have the dependency issue, and usually they're going to be ones that we've seen through a few times, and it would be the rarity that someone would be that significantly involved and we haven't seen them already.
They're that 48% that keep coming back.
Yeah. Right. Well, some people might say that this is kind of giving them a free pass because they're not having to do any prison time or jail time or very little. And I think in looking over the material that you both sent prior to this show, it's nothing like a free pass. There are some very stringent things that they have to meet in order to successfully complete this program. Why don't we talk about that? And there's different phases too. Phase 1, for example. Let's talk about what happens in phase 1 for someone going through this program.
Phase 1, that first 60 days, they're going to be coming every week. They're going to be tested at least twice a week, and they're going to be randomly tested. So they don't know when they're going to have that urinalysis test done. And that's part of the key. And at the training we went to, one thing that was very clear that had been found from different interviews of subjects later on, they said the one thing that they wish they would have had more of was testing. That just knowing that they could be tested at any point was a real incentive for them. So one of the keys is that testing and keeping the integrity of that testing. So it'll be twice a week at least. 60 days of that where they have to go the 60 days being abstinent. And during that time, they'll be working with the treatment providers and have fairly close reins. If they don't have a job, they got to start looking for a job, and the Carol Cook will be working with them with regard to those, with regard to trying to make sure that their life is stabilized, because that's such a big part of this as well. So that's pretty much part of phase one. Can you think of anything else, Scott?
Yeah, that they have to go through the vocational training at the beginning if they don't have employment. And other than that, I think you pretty much covered
What if I fail the
everything.
test?
Then there could be sanctions. That can include, say, a weekend in jail. That's one of the things that we've discussed. There are numbers of different sanctions, and as we get going, I'm sure there'll be different options. One thing I guess I wanted to bring up with that, when we talked about the jail time and whether or not how stringent this program is. Something else we find out from some of these, from the training we went to, and I think we can see it in some of the cases we have in court. Sometimes jail isn't the thing that really is going to be the disincentive for somebody. Some of these people may have done jail so many times, that may not be the key sanction for them or the key punishment. There may be something else out there that once we get to know them, or the treatment provider or someone else working with them in these teams, we'll find out that there's something else that may be driving that person that may be more meaningful as a punishment for them. But bottom line is, there'll be some sanction usually, and it could be, that's why we'll be doing them Fridays afternoons, as if they need to go for the weekend, hopefully then they won't have any problems with their job because of it, or some other sanctions can be imposed. And they're going to have to go, though, a full 60 days abstinent before they can get to the next stage, which we can talk about, where they won't have as much testing and quite as many requirements.
Sure. And other things that are part of this phase one, they have to participate in support groups at least 3 to 5 times a week, or as established by the court. They have to establish an employment plan, participate in a drug court educational component. They've got to develop and maintain a realistic budget, or at least obtain assistance in budget management, which I think is good. Weekly appearances before one of you two. Attend at least one office visit per week with the Safe Streets coordinator. Facilitate one home visit per week by that same coordinator, participate in an outpatient or an inpatient treatment program, complete community service work as set forth by the two of you or one of you, avoid premises where alcohol is sold. So they have to stay out of bars. It's sold for consumption on the premises. It's not like you have to avoid your local grocery store.
And that's because of so many of them
Right.
substitute.
Sure.
They can't smoke the crack anymore, so they're going to go to alcohol.
Yeah,
We don't
and there's
want
just
that.
a few more of these things too. So, I mean, that's a lot of stuff. I mean, doing all this, guys, you don't have time to be doing drugs. You're busy doing this
Well,
stuff.
that's what we hope.
So-
And part of this, we've been doing this presentation to other people, and the question was, I'm an employer, and I have one of these people working for me. When are they going to be able to come to work because they're doing all these things? Well, we thought of that, and that's why our drug court that we meet is later in the afternoon on Friday. And as we go through this, we might find that 7 o'clock in the morning on some day is better, then we'll do it at that time. All these treatment programs, these meetings with our drug court coordinator, and these group meetings will all be at night. So people can work during the day and still make these appointments. It's real important that we keep these people employed, and if they don't have jobs, get them jobs, so they have a feeling of self-worth. We find that the statistics will show if they have work and they feel good about themselves, that helps in completing this program.
This Carol Cook, who's working with you folks on this, you know, is she working with any of the local employers to help folks secure jobs?
She'll be doing that, and when we have people that she understands and knows that if there's an employer that's giving someone a hard time about coming to drug court or something like that, she'll talk to that employer, and if that doesn't satisfy that employer, Judge Key or myself will go talk to that employer to see if we can work something out. Because if you think about it, say it's someone that's a long-term employee that's been working for this employer, and they say, well, now you're missing a lot of work. Well, we can go and tell that employer, for years this employee has been under the influence of drugs while they're working for you. You know what that can do to your workers' compensation rates, to the injuries you can have, your liability, all those things can increase. We're insuring you by having this person go through this program, that you're going to have a drug-free employee.
Sure.
Isn't that something you want?
Well, I realize that this is, we're still, we're taping this on the 5th of January. This program is still really new. But what has your experience been with the employers in the area who maybe have some of these defendants working for them? Do they seem to be receptive to the idea?
So I haven't had too much discussions
Well,
with anyone yet. Have you?
We're doing a presentation next week to the Rotary Club where there'll be a lot of employers there for the sole reason we want these employers to start knowing this may come up. And if you have any questions, feel free to ask us. You have some, even an employer could, I guess, call us up and say, hey, this person is a good employee of mine. I think it would be good if this person was in the drug court because I'd like to keep him as an employee.
And we get that just in sentencings now in
Yeah.
different cases where you'll have the employees or the employers either send letters of support or come to court. And I think depending upon the relationship they have, I think in many of those cases the employers know that they want to keep a good employee. And if they can do anything to help, I think by and large, I'm pretty optimistic that the employers in the area will embrace this. It's too new yet to say what they're going to do with it, but I think once they see it, I think we got to get it established that they can see that this does work too, and that it's worth it for everybody to help these employees get on the straight and narrow, and again have that self-worth that'll be everything.
How long have drug courts been around? Where have they been enacted?
Well, it started in Miami in 1989, actually.
I'm not surprised it started down there.
Yes.
Neither was I when I read
Picture
that.
Miami Vice, right?
Exactly, right.
And they started, just that one court, and there's over 1,000 now nationwide. And actually, we said Wisconsin's been a little bit behind on those. We've got a few counties in the state that have had them going for a little bit now, but I think maybe, what is it, about a half a dozen maybe?
There's 3, I just read an article about it. There's 3 active and 3 that just started. And we're one of the 3 that just started. So out of the, 72 counties,
Yeah.
we have 3.
How long before you actually anticipate starting to see results from your first round of people who have gone through the program?
The whole program will probably take about a year to complete. We start running the drug court itself. We're taking in people. Now, I'm on intake now. The reason we waited until now is because I'm on intake. I get all the criminal cases this month. Barb follows me next month. So we wanted to be the first ones taking in the case, so if there's any bugs, we work them out. So hopefully within the next 3, I think the first date is January 27th is the first day we're actually holding the drug court. I would think within a year we'll have people going through graduation. People don't go, whenever you graduate, we have a graduation ceremony for them. We probably invite you, invite dignitaries to come and see the
Well,
program.
there you go, Paul.
The
Yeah.
employers.
I'm not included in that.
Employers and treatment help. The county board members, I'm sure, will all be invited. We have a graduation ceremony for them as each one successfully completes it. We're even starting, once we get that first person in there, we get another, we'll have an alumni association, and those people come back and talk to the people that are going through the program. It's a really neat concept, and I can't wait to get started.
Well, that leads me to another question. As you have people who successfully complete the program, will they not just talk, to a group of folks? Will there be kind of like a support system where someone in the program can kind of have a buddy system going so that you can contact someone if you feel yourself sort of...
Kind of like an AA or something along that
Yeah,
line.
you can call someone and say, hey, I'm in trouble here.
That's a great point. At training, they did discuss the alumni groups. I guess we thought we'll get to that. We got to get some graduates first. And then we'll get to that step. But I think that could be very important as well. I think that's a great part, hopefully, to the phase of after the recovery that's going to continue, sustaining that. But I think that's in the plans. But
In phase 3, one of the things to graduate in phase 3 is that you have to set up and establish an aftercare program. So they have to do that before they graduate. And when we're putting these people into this program, a component of this, as I said, was putting them on probation. The probation will most probably be 2 to 3 years. So when they're done with the drug court program, they'll still be on probation. So at that time, they'll still be meeting with a probation agent. But the reason we started this is probation agents meet with these people about 4 times a year. And to intensively treat somebody with supervision 4 times a year, it just doesn't cut it.
Not much, no.
That's why we don't get the results that we need. Thankfully, the probation office has dedicated 2 probation agents to handle just drug court cases. So we have 2 agents that are dealing directly with our clientele. So we can continue to work with those people, and in aftercare, they'll continue to monitor them, and if they have some problems, we're not opposed to letting them come back in the program. We were talking about people who get in this initially. We also are taking what are called ATRs, or Alternatives to Revocation. So if they're on probation, they're going to get revoked for probation, and they have drug and alcohol problems, they can get into this program. That type of person would not need the approval from the district attorney's office. If they qualify, they're into the program, and then part of their probation is successfully completing this program. If not, they come back and get sentenced, and they know they're looking at some prison time if they get sentenced.
Is there any cap, for either of you can answer this, I guess, is there any cap to the number of people who can be involved in the program, or is it limitless?
Well, we were saying we're looking at the first year. We don't want to take on so many that we would have difficulties trying to handle all of that since
Sure.
we're starting new. So our goal is the first year no more than about 15. Then eventually getting up to what, 50 a judge, wasn't it? We were saying?
Yeah, all the statistics say that a drug court judge cannot handle more than 50 at a time, because you're seeing these people a lot.
Mm-hmm.
And some bigger counties and bigger states, they have a judge that does nothing but drug court. They're doing it
Wow.
24/7. They're the drug court. That's the only thing they do. Barb and I have taken over doing this drug court, but we haven't given up anything.
Mm-hmm.
We're adding this on to what we currently do. So we have our full complement of cases, and we'll get more cases, and we'll continue to do this drug court.
Is this funded through Winnebago County, and if so, what are the budgetary, what are the dollars that taxpayers are paying for it?
Want me to handle that
Yeah,
one?
go ahead.
I'm the one who started a lot of this, so I'm the one who knows all the
You
numbers
did
on
the
that.
groundwork on a
Yeah.
lot of this.
So, as I said, the reason we had this through Human Services, because some of them have it through the Sheriff's Department. We didn't want it to be through the Sheriff's Department because it looks more punitive if it's through there. That's one reason. The other reason is if a different sheriff gets elected and doesn't like drug court, they could fire a coordinator. So we didn't want that. So we did it through Human Services. Human Service, and when we went to Hastings, Minnesota and La Crosse, the Sheriff's Department came along, and we also took county board members and Human Services. The reason we did that is we're thinking, okay, we need to know if we need any money, how we're going to work this. Human Services had money in their budget for another position. So they created this position, which was already under their budget. So it was no additional new dollars. It was under their budget. Now it's in the table of organization for Human Services. So it's no new money for that person. Now then the next question is expense. What about the treatment expense for these people? The statistics show from Minnesota as well as across, and nationally for that matter, that 80% of the cost for this program is borne by the people who go through it. Either they pay for it or their insurance does. So 20%, where's that going to come from? That additional 20% is something that Human Services has to pay for anyway because those people are indigent. So they would have paid for these people's treatment regardless if there's a drug court program or not. So actually the only additional expense will be for the weekly drug testing that we do on these people. We have testing kits. We try to get the best deal we can for these kits. There is a charge for these people to get into this program. If they can't come up with the money up front, we front them that amount of money. We're trying to get grants. We're doing a grant now with the Oshkosh Community Foundation to try to get a grant to pay for those costs. I talked to the judge in Eau Claire County that just started running a program, and they had 25 people in their program. It cost them about $10,000 last year total for their testing kits for 25 people. We're just starting, so we don't foresee it being that high.
Okay.
Yeah.
Now, do you see a time when other judges will take on some of the responsibilities of this court as well, or do you see it just sort of being retained by the two of you?
at this point, I mean, I think 100 will be able to handle that. I mean, that's not going to happen anytime soon, so it's not
sure.
something I've really, and you don't, it's one of those, like we've discussed, it's pretty much a relationship between the judge and the team and the participant, where it's not something we're going to bounce around every year or two. This is something I think that we're both committed to for a substantial period of time. Now, certainly in the other programs in other states as well, there's some point at which some judges have said, okay, enough after a number of years, and then someone else may take it over. But usually this would be something this is a long-term commitment by us that would be for, I'd say, a number of years
Sure.
before anybody else would necessarily have to look at it.
Well, that brings me to another question. I mean, judicial positions are elected positions. Now, neither one of you is up for election anytime soon, I don't think. But, you know, say you've got a judge who is coming up for re-election, and for whatever reason they are elected off the bench. What happens then to that aspect of the program that they're overseeing, or the people that are underneath them at that point?
A new judge would make a decision whether or not they wanted to continue with those programs, and they could put the kibosh to it.
Or another judge may want to take it
Yeah.
over then. I mean, I think
Yeah.
that it would just be a matter of working it out with all the other judges in the county.
So if a judge said, I don't want any part of this, would that reverse anything that the person has already done? I mean, could that person end up then being sentenced to prison?
Potentially could, but Barb and I both, we have monthly judge meetings. Barb and I did a presentation to the judges last month, and everybody's on board with
Sure.
this. Everybody thinks it's a good idea. It's past its prime. We needed to get this started a long time ago. They're all happy we started it, and they're getting rid of a few cases, giving them to us, so they weren't too upset with
Sure.
that either.
Sure, well, I suppose not. I just, you know, because election season is upon us, and there are a couple judicial races going on, that was just a natural question that I had.
And it is a good question. That
It's the uncertainty.
Sure.
You know, it's uncertainty. Well, let's talk about phase 2. What happens in phase 2 of the program?
Well, we're starting to loosen the reins a little bit. I believe it's 120 days where you have to be abstinent in phase 2. During that time, you're getting tested a minimum of 1 time per week. That's once again random, and if they come back and they have a relapse, we'll bring them in and we might say, okay, your sanction is go in next week 5 times. You gotta do your test 5 times that week. We cut down on I think it's 2 to 3 times a week we do the group treatments. They have to continue to maintain their treatment. They have to obtain employment during that time period. They have to continue with their community service if they're not completed. They have to have their budgeting process done. All those things that they started last time, they have to be in the process of completing them. And at that point, we're bringing them into court every 2 months, or every 2 weeks.
Okay.
They come in.
Okay.
I just want to get back to the the process of the court. If I come to the court, do I have an attorney representing me, or do I just come to you guys and say, hey, look, I messed up. I'm a good guy. My mom loves me, and everyone loves me. I made a mistake. I mean, what tools do the judges have to say, well, this is your second offense or third offense? Do you kick me out? How do you guys come to my punishment, I guess, lack of a better term, or my regimen of what I have to do? Is it based upon where I'm at as far as what my charge is, or how many times it's been, or is it all of that?
Are you talking about to get it into the program, or
if I'm in court now, do I have an attorney, and what makes you determine what my steps are going to be and what I have to do?
As a candidate for the drug court.
I'm already in the court. I'm
Okay,
before
you're
the
in the
judges
drug
now.
court. Okay, you're in the drug court, not just the court.
Every week,
Got it.
Right,
every
drug
week
court.
we staff these people when they come in. We have a drug court team, which is Barb and I will both be there every other week we do the drug court, but we both attend all the staffings every week. We have the drug court coordinator, treatment people, the 2 probation agents, DA, and public defender also. Now that person, when they come in, when we talk about, say something happened, they came up positive for cocaine. We talk about that as a group. We look at their history, what they've done in the program, and we decide as a group, what we think the appropriate sanction should be. Now let's say the person tested positive for cocaine, but they made every single treatment session, and that's the first time they made every treatment session that week. It's the first week they did it. We might go in there and just say, you know you're not supposed to be doing this. We'll counsel them, saying we're going to give you the benefit of the doubt because you made every treatment session. You're not going to be any session, or there's not going to be any sanction other than the fact you have to go in and get tested 3 times next week instead of just once.
So this whole consortium decides that, now I don't need an attorney for that then, do I?
No, and we kind of dissuade these people from having attorneys, although they can, because we want this not to be a third party it's
Yeah.
through. We want it to be a conversation between me and the participant.
And I would imagine the people that come before you in a drug court probably are people that don't have a lot of money that can afford a $150 an hour attorney to begin with.
And what we're talking about here is really, it's the non-adversarial system where they shouldn't need to have anyone speaking for them because it's just us discussing with them
Okay.
where they're at. And we talk about it being reality-based, and it's really, we're focusing in on what's going on in their life, what ticks for them, what does work for rewards, for sanctions, and then and that's what we're going off of, and it's really much the key to this is going to be that relationship that is developed between the offender and those with the team as well to determine what's going to be meaningful for that individual.
You had a good question concerning termination from the program. We do have a process for that. If the drug court coordinator finds out information that they think may disqualify this person or they want to terminate them from the program, the drug court team meets outside of the presence of the 2 circuit court judges in this, and then they decide whether or not they want to make that recommendation. If they make a recommendation to the drug court judge that the person should be terminated, at that point we go on the record. So then there's a court reporter and they're taking all of this down. They have a right to an attorney, and we're going to go through the process, and that's the first time when we would know the underlying facts behind the termination. We make the decision then, exclusively, the judges make the determination as to whether the person is terminated.
And then that could get back into the adversarial system.
Yeah.
Yeah.
Then that's different.
I can see where that would become a little adversarial.
Yeah.
Phase 3. Now that's, we're already at, by the time we get to phase 3, we are, let's see, 120 days. How many days into this are we?
Should be, what, 6
180,
months?
yeah.
180.
120 and then 60. Yep,
And
180.
take into consideration, that's days of abstinence. So if you, first phase, you go 45 days, you come up positive, you start over. So you have to go 60 continuous days
Okay,
of
all right.
being
So say
abstinent.
somebody has done that. They've maintained sobriety through phase 1, through phase 2. That's 6 months. Now we're into phase 3. What happens in phase 3?
Back off more. Was it 180 days, I believe, that
Yep.
we're...
180 days, and at that point we're meeting with them once a month in the drug court, and they're meeting with the coordinator less. We just back off everything. At that point they have to be maintaining their employment. They only have to go to group treatment once a week. Everything is slowly backed off, and then hopefully they have to make sure they have paid off all of their fees, completed all of their community service, did their aftercare program, which I referenced before. They have to set up that aftercare program, make sure that's all set up, and then hopefully they don't have any slip-ups and they graduate.
And the reason that for the backing off of this is not to just give them free rein, but to help them get ready to be in the real
Absolutely.
world, if you will,
That's right.
without some of the eyes of the court on them quite as heavily as they were before.
And that can be the critical time because now they aren't being tested as much and they have to prove to themselves as well that they can do it.
In your, I think you said you went to Hastings? Is
Yes.
that where you folks went? In your experience with some of these programs that have been in existence for a while, is it in this third phase that if people are going to slip up, that's where they tend to slip up? Or does it really just, can it happen at any point?
Across the board.
Yeah.
Across the board.
Okay, all right. And how much does each person pay for this? Is it the same per person? Is it ability to pay? How is that structured?
little bit of both. Was it $750, and then but there's an ability to pay scale that'll be used so that if they can't do it, they can work it off as well.
Okay.
But it's $750.
But the primary goal, because it's paid over time too, primary goal is getting these people, or one of our primary goals, is getting these people employed at the end so they have that job, so they should be able to pay that off. Half of that amount, if they're still indigent, can be worked off through community service.
Oh, okay. Well, that's even better, I think.
I have a question. If this works so well with drug cases, could it be argued, and has it been looked at, where this may be something for sexual assault, people with sexual problems, where they come to this where they are monitored on a weekly basis? I mean, they have a strict regimen before they get to the doorstep of sexually assaulting someone else. I mean, it would almost be an inverse of this, where the drug people are at the step of the jail. Well, you want the sexual offenders to be at the beginning before they start assaulting people. So, I mean, is this something that you think would work for something like that?
I don't see that being comparable. I think that for sex offenders, that's a different community, or a different group, so to speak, of offenders. We're talking different types of addictions that we can work with to a certain extent within the community where there's non-violent offenders. Once you're dealing with offenders where there's much more of a risk to the community, I don't think anyone's tried that type of program, and I don't think I'd.
But there
be in
have
favor.
been a lot of other types of court. There are alcohol courts, there are mental health courts.
Right.
They'll have duly diagnosed courts for the alcohol, drugs, as well as the mental health. They have domestic violence courts. All those types of courts are currently going. In fact, we're thinking we might be able to, at least here in Winnebago County, meld in an alcohol court into this. Right now, Barb's helped me with this too. I'm trying to get the law changed, working with Cheryl Hentz on getting the laws with respect to operating while intoxicated, second and third offense, changed where we can put those people on probation. Right now, we can't do that. In Wisconsin, you can't be put on probation on OWI until your fourth offense.
Isn't that nuts?
You can
It
be
is.
put on probation for issuing a worthless
Worthless
check, for disorderly conduct, any other criminal act, but second and third offense, drunk driving, you can't.
What is the logic behind that, do you
Cost.
think?
Tough on crime.
Well, that and the cost
Yeah.
of supervision, because we've discussed how the agents can only see some of these people 4 times a year because of the number of people that are on probation. I think the concern is more people on supervision, but the flip side of that is they're not getting the treatment that they need,
Right.
and particularly when it comes to alcoholism issues and drug driving cases. I just think it's an area where they just should be able to be on probation.
Well, yeah, and I mean, Judge Woldt, you've not been on the bench that long, but Judge Key, you've been on the bench longer. But for both of you, I mean, how much of an increase have you seen in multiple offense drunk driving cases?
I had sentencing after revocations on 3 operating after, or OWI cases, 4th offense. I had 3 of those sentencings today, sentencings after revocation.
In terms of increase, I'm not sure if we look at the numbers
pretty
over
steady.
the years. It's just steady, and it is. To me, it's astounding when we have some of the criminal traffic return dates and the number of 3rd, 4th offense drunk drivings, not to mention 5th offenses. But I've at times thought to myself, I don't know if I want to go out on the road tonight.
Yeah.
Well, and that begs a question. You're talking about alcohol driving OWI offenses going up, and we just had a law that passed in the state of Wisconsin where the intoxication level has gone down. Doesn't that show us then that, I mean, we could have a .05 or a .00, and it's still going to happen? So, I mean, are the laws that the state is passing relative to intoxication levels, does it make that much of a difference?
Well, here's the problem. When you have, in this state, when you have a second and third time offender, and you can't put them on probation, because we have to order them to get treatment. None of them get treatment. Very few get treatment. And if they don't get treatment, what happens? We revoke their driver's license. So what we get then in court is, I'm on intake, 4 days this month, I will have criminal traffic intake. During that time, I will have approximately 50 operating after revocations. So that's 200 people during that 1 month that have operating after revocation because they're driving their car, because they didn't get their alcohol assessment. So then what we do, the minimum jail on those is 5 days. Well, you do 5 days times 200 people times $51 a day. That comes out to about $750,000 a year in jail cost alone, not to mention the court costs. But that's what we do. In this state, what we do when people don't get they have a drunk driving, they don't get their alcohol assessment, we take away their driver's license. I would rather place those people on probation and make sure they get the treatment. With this law, I got an email tonight from Carol Rossler's office saying that the legislation has been drafted. We went through about 8 drafts. It's been drafted now. We're at the final draft. It's being edited, and the next day or two, I'm going to get the final draft. And what this law will do is in Winnebago County alone, exclusively, we're going to do a test pilot in this county. If you have a second or third offense, we can place you on probation, and if you successfully complete AODA treatment, your jail will be cut 75%. So you'll get that benefit, and that'll be the reason for people to go on probation. You're going to get a 75% cut in jail if you go through this. Let's face it, all of these people, because you say it's a soft on crime by cutting their jail, all of these people are getting out. They're going to get out of jail, they're going to get out of prison on these drug cases. Who do you want living next to you? Who do you want driving down the street? The person who's gone to crime college, got their bachelor's degree in predatory arts, or the person who has gone through treatment and has successfully completed that treatment? I want the person who's been treated.
Well, getting back to the increase in what you're seeing as far as multiple offenses with, these driving while under the influence cases, do you think it's because, are we seeing the increase because we have more people who are just not taking this seriously and they're drinking and driving? Do you think it's because we are lowering the BAC levels, or is it just that we're stepping up our efforts to catch these folks, or is it everything combined?
It could be some of the combination. I don't think that, I really have not seen that many by lowering it from the 0.10 to the 0.08, that there are that many that are at that between 0.08 and 0.10. Vast majority.
I've had
They're
2 in 2 years.
They're
Is
usually
that right?
well over.
2 in 2 years what I've had
Really?
between
Yeah.
0.08 and 0.10. They're typically 0.17 or higher.
Or well above that. And the point I want, when you were asking before about has it mattered over the last few years, I think it has. I think it really, when you think back 20 years ago, I think there's been a real change in our culture as to how we look at drinking alcohol and then getting behind the wheel. I think people really do think twice. Most people do. And I think the penalties there really do have an effect and will be a disincentive for a lot of those people when it comes to drinking and driving. Or if they get it once, possibly. But what we're talking about now are the multiple offenders, the ones that have such an addiction that they're just not getting it and they're not going to get it without the treatment. But I still think that overall, when you look at the big picture, has there been a big change in how we as a society look at drinking and driving? And is it because of how we've toughened the laws over the last 20 years? I think definitely that has had a huge impact. But what we're talking about now are these multiple offenders that the penalties just don't necessarily matter to them because the addiction has taken over.
And I've been seeing that since they changed the law with respect to not alcohol but controlled substances, driving with a controlled substance in your system, I've been seeing those cases with OxyContin, marijuana, cocaine. Those types of cases are coming in now more and more.
How does someone get arrested for under the influence of marijuana or cocaine? Obviously alcohol, you have a breathalyzer test and you have a limit there. If I'm an officer and I suspect someone's been driving with marijuana or cocaine, obviously you can arrest those people, for taking the substance. But how do you make the determination legally that they cannot drive that vehicle, that they're impaired? Can I give you a ticket? I can't give you a ticket for OWI.
Yes, you can.
You
That's
can.
what they do. Because there's 2 tickets that always come along. One is operating while intoxicated.
And
The
one's
other is
operating with an alcohol level of 0.8.
prohibited,
The BAC.
with a restricted controlled substance with a drug case. What they do is take a blood test, send it down the state crime lab, and they have a list of what the therapeutic levels are for medications. If you're outside that therapeutic level, you can be charged with it. For THC, they have studies that are done with delta-9 THC marijuana. Delta-9 THC is active ingredient. It has to be over, I think, 4.5 nanograms of THC in your system in order to be under the influence. That's what the standard is.
But you don't get to any of that until the officer has to have some reason to know that or believe that the person has something in
Yeah.
their systems.
Right.
So usually it's going to be something happened in the driving that
Right.
showed to them that there was a reason to stop them.
Right.
Or otherwise, after they've stopped him for something that wasn't necessarily driving related, like an expired registration or something to that effect, which we get those too. But then
Quite often.
yeah, something else had to happen for the officer to believe that they have something else other than alcohol. They can't just say, "Oh, I wonder if you've had cocaine tonight," and then take him in for a test. You know, they gotta have some reason.
I tell people in my court, learn something from my dear old mom. Mom always told me, don't go out after midnight because nothing happens after midnight. And they all laugh. 90% of these people are no registration, loud exhaust, and they're after midnight. Obviously, these police officers are looking for that type
Sure.
of stuff, but they just don't get
They're
it.
victims of their own stupidity.
Yeah, they just don't listen to dear old mom.
Yeah.
Well, and you know, I mean, you guys must just at the end of the day, when you go home, just kind of sit and laugh about some of the things that you see, not because it's funny, but because it is ridiculous, some of the things that come before you. You know, I mean, I sometimes get stuck sitting in court for a long period of time waiting for a case that I'm covering for the media to come up, and I see all this stuff going on. Sometimes you should just go into a courtroom and just sit.
And that's a good question. Are your proceedings open to the public?
Almost
Yeah.
everything. Almost everything, except there's a few confidential type proceedings, juvenile matters, mental health, mental commitment matters. But other than just a few rare exceptions, the vast majority is open for everybody to see.
And it is fascinating. It really is.
It's the lady Donna who comes and sits in my court 3 or 4 times a week and just watches, and when she comes in, I'll say hi to her. She'll
I
say
might
hi
do
back.
that someday.
You'll get a hoot out of it.
I just have a
It's
yes or no
enlightening.
question for Judge Key.
All right, go.
Are you looking forward to another smoking ban thing coming to your court?
Yes.
Well, on that note, you know, best of luck with this program.
Thank you.
Really, I mean, I hope that it's going to be a success for you, and just as successful here as it was in other counties. And thanks to both of you for being here. Paul, thanks.
My pleasure. I loved it.
I know we wanted to chat about one little thing real quick, and we didn't have a chance to do that, but
We'll do it some
we'll do
other
that
time.
when you come on to talk about your candidacy.
Absolutely.
So,
Absolutely.
for sure. So thanks for being here. Thank you for joining us as always. We'll see you next time. Until then, take good care. Keep your eye on us. We've got our eye on Oshkosh.